here and do just a few housekeeping things, just ensuring that you can all hear me, and if you've got any particular technical issues, to use the chat box function at the bottom of the screen. That's also a function you can use during the webinar to ask any questions that arise from any of the slides, and obviously I'll leave some time open at the end of the webinar as well for people to ask any particular questions as well. We won't be able to answer individual case questions, but that's where calling the 0800 number for youth law comes into effect, and giving the 0800 number a call, someone will be able to take that message down and pass it on to a lawyer who can look at the file and hopefully give some information or advice. So just some housekeeping matters. I've got my mic on. It might be helpful if people can mute themselves during the webinar if it's going to interfere with the sound for other people, if there's rattling in the background. If there are more than one person or two people watching on one computer, I'd really appreciate if you're able just to enter your details into the message box and let us know. The reason being is that we generally need to account to our funders for the total number of people engaging in the webinars and provide feedback on that. So that's the first point, and the second point is we will send out a link for a survey through SurveyMonkey at the end of the webinar, and we would greatly appreciate if you're able to complete that. It enables us to improve our webinars in the future and see what's useful or what's not. So any questions about that, feel free to use the chat box. As I said, the chat box will be open during the webinar and also at the end of the webinar to answer specific questions. Also, we're hoping to get the slides in PDF form and uploaded onto our website for people to download after the webinar, and it will take us a little bit longer after we record this to put it into a video format and upload it onto our YouTube video on YouTube. So hopefully people that haven't been able to attend the live webinar session can at least watch the video later if they wish to. So with all of that being said, hopefully everyone's all okay. They can hear me, they can see everything. Obviously any serious issues which aren't to do with the instructions that were sent out to you, please use the chat box function. Valda is a wonderful help with the technical side of things, so she'll be able to guide you through any other issues that arise. So with that being said, I'm just going to get started. Also, if you have an interest in education law and you're wanting to know, sorry, I've just, if everyone could possibly mute their microphones as well, that'd be really helpful. There's a bit of background noise. If people are interested in other education law topics, for instance, the right to education, search and seizure at school, anything like that, we have videos and slides up from our previous webinars. There's 7 modules on our website as well, detailing detailed areas of education law if you ever run into issues in those areas as well. Really relevant to this particular webinar is there is one webinar on there about supporting special needs students at school. So that's, I think, module 3 of our webinars, so feel free to go and have a look at all that as well if you're interested. So I'm just going to get started now. Hopefully everyone can see the screen fine, and there is the information for downloading the slides after the webinar if you want to. So talking about special education funding, it's a mixed funding framework. I'm just going to give you a little bit of an overview just for those that don't know that much about it, just before we get into the substantive, how do you appeal ministry decisions or advocate with the ministry when you're not happy with the funding decision that's been made. So currently it's a mixed funding framework. The government currently allocates that amount per annum to support students with special needs. There has been some discussion about whether or not that amount should increase or decrease, but based on what I've heard so far, it's not likely to change in the present year. Funding and services are provided through a mixed funding framework and distributed in different ways. So this triangle kind of indicates the overall funding framework. So sort of thinking it as a sort of triangle is kind of helpful because the special education grant is a bulk fund that's given to each school based on the number of students in the school. So not necessarily the number of students with special educational needs, but the total number of students and various other factors. And this is a bulk fund which is given to schools to administer at their discretion. So they make the call within the school as to how it is spent, how best to use those resources and how to allocate those resources to best meet the needs of students with special educational needs within the school. A lot of that bulk funding is intended to capture students that have low to moderate special needs. So there are other initiatives for which individual applications are available for high needs funding. So OARS, or the Ongoing Resourcing Scheme, is the next little box down in my triangle there. That's sort of, seen as the holy grail, I guess, if you're looking for funding to support a child, because it is individualised funding. It follows a child, so it's not linked to a school, but it follows the child from school to school, and usually children apply for it at crucial junctures of their schooling career, and that enables them to potentially have support up until the age of 21. So it is quite extensive, and it involves quite a lot of professional support, which can involve things such as specialist technology, teacher time, teacher aid, and that can include things like OTs, occupational therapists, other supports such as educational psychologists, speech language therapists or otherwise. So quite in depth. There's a lot more detail about this in our previous education webinar to do with supporting special educational needs students, and in that we talk about things like the fact that every OARS funded child must have what's called an individual education plan, or an IEP as it's more commonly referred to in its short phrase, which deals with how the child is going to be supported, the supports that are going to be given to the child, and how that's going to be implemented over time and the targets to be met, and that falls under Section 9 of the Education Act. Really important that the IEP is formulated in conjunction with the parent or parents, the student and the school, and the support that the ministry is meant to provide as a wraparound service throughout the child's schooling career. So essentially a lot of what this webinar is going to talk about today is how you appeal OARS funding, but there are other initiatives, and we're going to talk a little bit about the other ways you can advocate with the ministry to try and ask them to consider other funding alternatives where, for instance, OARS isn't available. There might be other initiatives which I've also detailed briefly in that triangle there, so they may fall under communication, behaviour, early intervention initiatives, and also a more recent introduction from the ministry has been IWS, or the Intensive Wraparound Service. So IWS essentially is short-term, viewed as short-term funding when there is a need for intensive support over a specified period. Very often there may be behavioural issues, and often IWS funding is also geared towards short-term residential placements and transition back into the mainstream. So the IWS system involves application to an IWS panel with various amounts of supporting documentation. It is considered by the panel, and then should the child be deemed eligible for IWS support, then a whole raft of support is then forthcoming, which can include educational psychologists, extra support, resourcing at the school, and a number of other things, which is also available under OARS funding, but just at an intense level for a specified period of time. I've also put in there that there is RTLB, which are the clusters of resource teachers of learning behaviour, who work in clusters around schools and essentially provide support with the provision of special educational support for all the schools in their cluster area. That can be really helpful to work with the RTLB to find something that works for a particular student, and in essence, although an IEP under Section 9 of the Education Act is not compulsory for all students with special educational needs unless they're OARS funded or they've been directed to a special school, in good practice IEPs are just really good in general, where a student might have some additional needs, to have those all set out in a clear plan and have clear directives and goals that a school, the student and their parents can work towards with the support of the Ministry of Education. So really advocating a collaborative approach here. Generally, if a student needs to make an application for Oars funding, there needs to be the support of the school and various supporting professionals as well who have done assessments. So really collaboration is really vital if you're making an application or you're supporting a student or family through the application process. Also, just right down the bottom of the triangle is the specialist schools, so special schools. So obviously where a decision is made, an agreement is reached with parents and a student that the setting that would best meet a student's special educational needs is a special school. A direction to enrol in that special school can be made under Section 9 of the Education Act, and an agreement is formed, and that is between the Secretary of Education and the student and their parents. And obviously in that case also the IEP must be in existence and the agreement must be in place. But for your students with higher needs, you're looking at Oars funding, which is that individualised funding, and potentially IWS for short-term and intensive intervention. Sometimes the Ministry also has different sets of funding, such as under behaviours and intervention, early intervention, communication support, speech language therapy, and also in situations where there's need for an intense intervention, Group Special Education also has the IRF, Interim Relief Fund, where short provision, where there's potentially a risky or dangerous situation, the Ministry may become involved and IRF funding may be available. So that's just kind of a general overview. A lot more of this information is available on the Ministry website and obviously through the Ministry. But what we're going to focus on today is essentially what happens when you make an application for high needs funding, individual funding for a student, Oars funding, and it is not successful, and then you may wish to make an application or seek assistance from the Ministry for funding under one of the other initiatives, and how you might go about advocacy or appealing those decisions, and just kind of talking you through some of the just tips and tricks of the best chance of getting the application approved and the best chance of putting the best case forward when you're appealing the decision to get it overturned. Okay, so let's talk about Oars. So the resourcing scheme has 9 criteria. The 9 criteria are extensively detailed on the Ministry of Education website, so I haven't set them out in detail here, but essentially it's 9 criteria which cover 5 areas of student need for special education. So this can include learning, hearing, vision impairment, physical impairment, difficulties with language use, or difficulties with social communication and interaction. So those are your typical, when you're dealing with the language use and social communication, that's typically under criteria 5 and criteria 8. So a lot of the clients that we see who have made applications under these particular criteria may have ASD. So something that application would entail would be quite different, for instance, to an application for hearing or vision impairment or physical impairment. So it's really crucial, as I'll detail in the later slides, to make sure that when the application for funding is first submitted, it has enough detail and it has enough evidence to support the request for funding made, such that when you measure the application that's been submitted against the criteria, and in particular the benchmarks which are set within the criteria, that it evidences those things. So to meet Oars criteria, students must have ongoing extreme or severe difficulty with any of the need areas which are listed, and also moderate to high difficulty with learning, combined with very high or high needs in any 2 needs areas. Now I know that sentence is a little bit unwieldy, and just to break it down for you, there's a little chart that's available on the Ministry of Education website, which kind of, it's kind of like a checkbox. So if you check that, you need to then check 2 boxes in 2 other areas which are very high or high needs areas. So for instance, a student with moderate physical impairment but extremely high needs in language use and social communication. So that would be, for instance, under criteria 9. So without going into too much detail, because I think it'll be a little bit confusing if I try and talk you through the ins and outs of the chart, what I'd suggest is having a look at the chart on the Ministry of Education website. YouthLaw's website is always open to have a read of as well, and people with specific cases or questions can always contact the 0800 line if they want to find out more information or potentially advice from a lawyer about a specific case. So just a bit of overview of the Oars funding scheme. The criteria are pretty strict, so it's really quite prescriptive. Those of you who are working with families, or you're a parent yourself and have been through this process, you'll know that the criterion can be quite strict. There are a lot of criticisms levelled at it because it makes it very difficult unless you can fit directly within the exact boxes, and no children are ever going to fit precisely within boxes because all children are unique and different in different ways. One of the major criticisms that's been directed towards the scheme is that the benchmarks that are set within each criteria, so for instance I think under criterion 5 there's an example of a student, Hemi, and it says that Hemi cannot do these things. So Hemi cannot put together particular items, or Hemi is unable to accomplish this on a daily basis himself. It is very detailed and very prescriptive, and you know, it says Hemi is a certain age, so a lot of the arguments are that the benchmarks are really arbitrary, they're inconsistent, they're not age appropriate and extremely difficult to apply, but it can make it very difficult for deserving students who really should be entitled to this funding to meet the criteria that's been set out and actually get through all the hoops to get to achieving Oars funding. Cabinet papers indicate that this high needs funding is currently targeted at 1% of the high needs school population. So to put it in perspective, that's a handful of a few thousand students, but the estimates from a lot of other people in the sector and those who are working with students estimate that the actual need for this sort of support is actually at about 3%, which is 3 times what is currently allocated. So there's a lot of criticism directed towards that as well, because a lot of the reports that come back from people in the sector is that essentially what happens is that students that fall within the gaps don't meet the criteria for high needs funding, end up having to be met from a bulk fund of a school, and that bulk fund then gets very stretched because it's intended to target low to moderate needs students, not high needs students, so all resources get stretched, and it can mean the decline of the ability to provide support for all students with special educational needs in that school. So just going back to that earlier slide, you'll remember I talked about the fact that the SEG fund, or the bulk fund, which is given to schools, is not given based on the number of special needs students within a school with identified special needs. It's actually based on a total per capita population, which means that the formula can sometimes be entirely out of whack with the number of students that are actually there. What we hear particularly so is this is the case where there are schools that are known as magnet schools. They do well with students with special educational needs, they attract more students, but they don't necessarily attract more funding unless it's individualised Oars funding which follows that student. So they're being asked to stretch their bulk fund further and further, and that can mean issues in the provision of support for all the students that may need it. So that's just a bit of the background around some of the issues that sort of come out of Oars funding. I know that the Ministry is attempting to introduce a number of new initiatives to support students that might fall short. So there's new initiatives like in-class support, there's things like the IWS which is being revamped and revised at present. So there are other support mechanisms available. However, the feedback generally is that those that get Oars funding generally have that guaranteed extensive support up until the age of 21, which enables a student to really transition nicely from the conclusion of their education into you know, the outside world, the workforce, and anything else that they may wish to do beyond that. So it is a big deal, and I guess that's why the webinar really focuses on this process, because it is intensely stressful for parents and families to be subjected to a legal process should the funding decision be unsuccessful, and without any clue about the ins and outs of the process, or the procedures that apply, or how to best interpret the law to put forward their best case. So that's kind of what the whole webinar is about. So let's talk about firstly the application process. So the application for OARS is made with the school and the family in conjunction. So the school submits the application to the Ministry of Education and works with the family to gather all the appropriate information to insert into the application. To have the best chance of success when the application is first submitted, it should be very detailed, and it should be supported by a lot of expert evidence or information. So when I say expert evidence or information, I'm saying that there should be specific examples of how the young person meets the criteria under the OARS criteria, and also there should be potentially, for instance, a report of a speech language therapist or a report of an educational psychologist, or otherwise saying this is the testing that I've conducted, and I take the view that the young person is at this level of achievement and needs this type of support in order to adequately function in the curricula. So quite important that you have very specific details firstly, but also that those specific details are backed up by information which is readily accessible and digestible in a form that would justify the decision to grant the funding. So expert medical and psychologist evidence, for instance. What is important about the application is if the application goes in and there's not enough information or it's rejected, the school and the family can then seek a review or reconsideration of the decision. So that's just saying, please have a look at this again. You can submit more information. So say you submitted the application in the first place, but it was missing a speech language therapist assessment. You could resubmit and ask for a review reconsideration in light of the new information submitted, such as the speech language therapist report. So this is all a bit of an informal process. So from the application process up to the review reconsideration, this can be an ongoing informal process. All it requires is the school or the family contacting the ministry, preferably in writing, and saying, I'd like to have a review or reconsideration. I'm going to forward through some more information for you to consider. Beyond that, if you wanted to then take the matter further, you can legally appeal the decision. So Section 10 of the Education Act sets out the right for the student and their family to legally appeal the decision. So this is slightly different. It's more formal. It's not informal like the review or reconsideration. And essentially you're saying, I legally appeal this decision on the basis I think that I think it's incorrect. So there's a very specific procedure set out in terms of how to appeal under Section 10 of the Education Act. It's a formal process, and it kicks into effect a formal legal process dictated. So under Section 10 of the Education Act, you're required to notify the Secretary of Education within 30 days of your intention to legally appeal, so preferably a clear written indication. This time limit is extremely important, because if you do want to go through that legal formal appeal process, you need to tell them, otherwise you lose the right to appeal. This appeal is different because, unlike the informal review reconsideration where you're still dealing with internal ministry staff, this time when you appeal, it's being appealed to an independent arbitrator. It's really helpful if you as a support person or you as the family have the school support to do this, because obviously, as I'm going to talk in the later slides, they will play a really important role in helping you put forward the case for appeal to the arbitrator for them to decide. So if the school's on board, it's fantastic, because you'd have the support of them going forward into the appeal process. So yeah. I always say to people, if they're not sure, if you're really tossing up whether or not you want to appeal, and you feel like you've submitted all the information you possibly can and you're running close to the 30 days, it's always possible to just notify that you'd like to appeal and then choose to withdraw it at a later stage so that you don't lose that 30-day right. I guess what you need to bear in mind is the fact that obviously there's a process that kicks into effect after that. So as I'll talk about later in the slides, there are potential risks and pitfalls of going through the appeal process, including a substantial stand-down period should your appeal be unsuccessful. So, here's the process under Section 10. If you do want to, you can have a look at Section 10 of the Education Act online through the government legislation website. It's a pretty extensive section and various subsections, but the main thing is that you just are going through a formal legal process and you're saying, I'm not happy with the funding decision that's been made in respect of the Oars funding. So usually you'd notify the Ministry of Education in writing of your intention to appeal, and this is where it kind of becomes more of a parent's process. So with the application and the review reconsideration, that's really usually things that schools do, and the schools in conjunction with the parents will do. Once it gets to the appeal stage, it's for the parent to take the appeal. So the Section 10 wording refers specifically to the family and the parents and the student. So it's not the school that necessarily does the appeal, but the school might support you and provide support through evidence or information as you go through the process. The crucial part of Section 10 also is that it provides that the Ministry of Education is to provide a list of 3 arbitrators for you to choose from. So these are 3 independent arbitrators that have been vetted as having special educational experience by the Ministry of Education. So when you get the list of the 3 CVs, you've just really, in terms of choosing an arbitrator, there are no hard and fast rules. You just need to look at their CVs and very often look at their background, relevant experience. So this particular arbitrator might have a lot of experience in an area where the child you're supporting or your student really needs special educational support, so that might be really helpful. Look at their background, where have they worked, who have they worked with, and you know, you can always have a little Google, have a look at their website, have a look at their credentials, and you know, generally I find that most people get a feel for who they would feel most comfortable with after going through that process. And certainly there's nothing to stop you from looking them up or having a look at any documents that they've published or anything like that to get a better feel and idea for it. Once you've chosen your arbitrator, obviously, you let the Ministry of Education know, the arbitrator gets appointed, and then the process kicks into play. So then what happens is a timetable is set. A timetable is set for each side to put forward their submissions, that's being you, submitting your case to overturn the funding decision, and then also a case from the Ministry's end as to why their decision was correct. And then a relevant date and location is chosen for the arbitration. Dates will often depend on the availability of the arbitrator and the availability of the Ministry of Education representative, and location is generally a location which is close to you and your child's school. So very often, for instance, a motel or hotel close to where you reside. Just an important point to consider. Before you go through all of this process, I just want to harp back on about this review reconsideration stuff. Really, has all relevant information been put before the Ministry of Education? If it hasn't, you're not putting forward your best case to appeal on. If you haven't, and again I refer back to the earlier slides where I talk about the fact that expert evidence, expert information, specific examples, supporting letters from teachers or those that are working with the student, and academic results will be really helpful. This is because there's a really important provision in Section 10 which notes that you cannot introduce what's classified as new information at the arbitration. So if it hasn't been submitted to the Ministry before, then you cannot bring it up at the appeal stage at arbitration. You have to work with what you've given them to put forward your best case. So always before you go through the appeal process, you may want to go through the review reconsideration process sometimes a number of times to ensure that you've given them all the relevant information to have the best case to work off. This also because of the real risks of if you don't win your appeal. So if you don't win your appeal, you get a 12-month stand down from making any further applications, and so obviously you're running the risk of the particular student not having support over that time by not being able to make a further application. So I've just seen that questions popped up on the screen, so it might be a good time just for me to pause and answer that. So hopefully everyone can see it, but I understand that Oars funding used to be renewable. At some point, perhaps 7 years ago, kids with Oars funding no longer needed to go through a needs review and stayed on the scheme. Given that Oars is bulk funded and kids are not falling off the scheme, how do we ascertain how many potential applications could be accepted in 1 year? I mean, the general response that I understand has come from the Ministry is essentially those that need it get it. It is targeted at 1% of the high needs school population. So I think such figures are potentially available from the Ministry of Education website and also through Official Information Act requests, and I'm going to talk a little bit about that further down in the other slides. But the official Ministry of Education website response to this is that if a child meets the criteria, they will receive funding. So within the Oars, just because there is Oars funding, it doesn't mean that everything that's listed under that is provided at the same rate for each child. So there is a moderation process once you obtain Oars funding to obtain the exact needs of the child and to obtain the correct level of support beyond that. But maybe we can come back to that after I've gone through the other slides about other initiatives and how you might advocate for other support if Oars funding isn't available. But yeah, I just wanted to reiterate the importance of considering the review and reconsideration before you go down the appeal route because of that 12-month stand down. So no ability to make another application during that 12 months, and that can mean substantial lag and lack of support for that student in that time. Yeah, so here's some of the further information I think sometimes can be super helpful if you are looking at a review reconsideration before you go down the appeal route. So school test results. So really great if you've got JAM assessments, reading assessments, you know, any of those things which your students' teachers and SENCO, so your special education needs coordinator of the school and principal can provide. So helpful, because if it's showing ongoing academic lag with their peers, and you know, one of the key measures within Criterion 5 is that the student needs to be working within level 1 of the curriculum. So if it's showing that and it's showing that no improvement can be made without that support, really helpful, and that's, you know, objective testing. If the testing isn't that helpful because it doesn't show that, you know, explaining why can be really helpful. So explaining that, for instance, in this particular test, the student was really heavily scaffolded, there was a teacher aide sitting next to them, they had use of a device, or this was something that's been rote learnt, really helpful as well. Other helpful information is also expert psychologist and medical information. So for instance, educational psychologist report. So I put in here note MOE versus private. So sometimes the Ministry of Education does engage an educational psychologist to work with a student and produce a report. Just remember that the scope of those reports can be limited, so they're obviously not going to cover all aspects of the child's meeting the criteria under Oars. Quite different when it's a private psychologist assessment, because the scope for review of a number of aspects such as behavioural issues, language issues and otherwise might be better encompassed and better address how the student might meet Oars criteria. So some of the key measurements and tests that might be administered under some of those reports would be the Wechsler or ABAS scales, which deal with adaptive behaviour. Other reports which could be helpful are things like occupational therapist reports, speech language therapist reports. So for instance, if you're looking at an application under Criterion 8, really important to show difficulties with language use, so you need assessments that measure expressive and receptive language of a particular student. So really helpful, because if that information is not in front of the application panel, then they don't have the expert evidence which backs up the specific examples that have been given in the application. Also really helpful are paediatrician reports, letters, diagnoses. They can also be quite broad-ranging, so they can detail, for instance, any medication that the student is on, any particular medical needs, and future needs of the student in respect of learning and so forth, which would indicate the need for support and a lag if that support is not forthcoming. Other things that are really helpful, so teachers' reports. One of the best sources of information, as I'll talk about a little bit later in the slides, is actually your student's teacher. They are interacting with your student every day. They have so much anecdotal and specific examples that are so helpful. So any reports or letters that they can generate detailing their concerns are really helpful. The SENCO, so I mentioned them before as well, so the Special Education Needs Coordinator at each school. They will have really good in-depth knowledge as well in terms of the special needs supports that are available for the student at present through the school and what the student will need moving forward to achieve and obtain an education within the curricula. The principal as well, the principal's generally got a good grasp. The principal's working with the SENCO, so the principal will have ideas about budgetary constraints within any bulk funding, issues with applications that are being made or otherwise. And you remember I referred earlier to the RTLB, who are the cluster group of teachers in the local areas of schools. They probably would be able to provide some helpful expert evidence as well if they're working with the student quite regularly, and they can see some of the gaps that are occurring because of the lack of support. Also sometimes really helpful to get information or reports from other relevant professionals. So say the student is attending at the Kari Centre, Rainbow House, any of those professionals, if they've got good insights into behavioural or learning difficulties and types of support needed, that can be really helpful too. Gathering all this information and submitting it at the review reconsideration stage is certainly far more beneficial than trying to go through an appeal process without all that information in front of the Ministry of Education and the arbitrator. So here's the process. Once you've selected an arbitrator, a timetable is set down for submissions and a hearing date. So you will receive a time frame to draft up your submissions to the arbitrator, setting out your case as to why the decision to refuse OARS funding should be overturned. And then you'll also receive a pack. So the pack contains the original OARS application, all the supporting information and documents for you to work off. In that stage, the timetable is set also for the Ministry to complete their submissions for the arbitrator in respect of why their decision was correct. You'll be given a copy of the Ministry submissions and that will detail, also there'll be a spreadsheet which is attached which details the verification process which has been undertaken in respect of this particular student. So it will record on that spreadsheet the date the application was made, under which criteria, how many verifiers assess the information, how many verifiers declined. So it is quite an interesting breakdown, and so sometimes you'll see when you actually get the spreadsheet that there were a number of verifiers that wanted to approve the application, but the majority, for instance, decided not to. So it's a good indication of what happened with the application process. So crucial again, reiterating this again because it's really important, you can't introduce new information. So if the student has since been to see Kaikoura Trust and there's a professional person that wants to provide a report, you can't submit that with your appeal documents. You're going to have to possibly kick off the review reconsideration process again. So it can be really helpful, and I know it's an incredibly overwhelming and daunting process to think as a family, I need to face this process, this legal process, as a parent, and I need to advocate, and there's going to be people from the Ministry who are experienced in this and an arbitrator who's a legal decision maker. So it's really helpful if you've got a support person that's working with you and your student. So for instance, IHC advocates, support people from CCS Disability Action. Sometimes you know, people from youth law, your local community law centre. I know some fantastic work has been done at some of the other community law centres, particular Canterbury and Wellington. So, you know, I know that they do a lot of youth education work as well. So it may be worth getting in contact. Hi Anna, I've just seen a question pop up on the screen. So generally with some of the ones that I've seen previously, you can have 3 verifiers look at each application, but where I understand that where there's been particularly contentious decisions, it's referred to a full panel. So it's not always the case that it's only a set number below 3. If it's a case where the verifiers are really having difficulty agreeing, that can be referred to the full panel before a decision is made, and usually that is indicated in the spreadsheet which you get when you receive your Ministry of Education submissions. So hopefully that answers the question, but oh sorry, I've just seen there is a question from Genevieve as well. Reconsideration versus appeal, is it admissible to submit additional and more detailed information in support of the reconsideration process? Yeah, absolutely, and I would always say that that's your best bet, because once you go down the appeal route, no new information is available, and if you don't win your appeal, you're stood down for 12 months, so there's big risk with that, versus the review reconsideration process, provided you continue to have relevant new and additional information that supports your claim, then there's no reason why you can't ask them to consider that again and kick off that process again. As far as I understand, there's nothing in the ministry policy which prevents you from doing that as many times as you need to in order to put all the information you need before them. So I've just had a quick look at the number of all students breakdown. Velda has been so wonderfully helpful in giving me this. So the statistics are found at www.educationcounts.govt.nz, and as at the 1st of July 2015, 8,525 students were receiving OARS funding. These students represented approximately 1.1% of the total schooling population. So just to put that in context, the estimates are you need to triple that amount to truly meet the need of students that most people in the sector say have these needs, and boys made up 66% of those. So if you do want to have a better look at that, it's broken down in a lot more detail on the Education Counts website, and it breaks it down by year and gender. So you've got male, female, and years, you know, ranging back, and it indicates that there has been an increase over time, but not a substantial increase in the, I guess, relative to the number of students that have been identified with student needs, special needs, that it may not indicate so much of an increase as opposed to simply the number of students that now are being identified with special needs. That still represents the 1.1% target, approximate 1% target. So one of the big things that I think I hear from a lot of people that are going through this process is, oh no, what do? I need to draft some really convincing and persuasive submissions, and maybe often have never written legal submissions before. So here are some really practical tips about how you can go about it, and what we've done is we've also prepared some templates which show you, kind of what you want to do and how you go about it. But my first piece of advice in respect of this is that you should make an Official Information Act or Privacy Act request. Those attack two forms of information. So essentially under the Official Information Act you're asking for any official information that is publicly available, held by a public body, being the Ministry of Education, that you can request in respect of this particular matter. And the Privacy Act request is a Privacy Act request on behalf of your students. So obviously the best thing is to have evidence to show that you have relative authority to request that information on their behalf. And under the Privacy Act you're entitled to access any information that is held about you by another agency. What I find, and this is probably the biggest take-home tip from this particular point, is that when you get your pack, which is given automatically to you as soon as you appeal. That's a very small pack. It only has the original OARS application, any supporting documents. It's very different to the whole file that the Ministry of Education actually holds. So at times the whole file that I've received from the Ministry of Education has been 6 or 8 times the size of the small pack that's received with just the OARS application, and there's often gold of wealth of information in there, so reports that you weren't aware of, assessments that you weren't aware of, you know, records and IEP discussions that you weren't aware of that have been documented, so really helpful to get that. So see our sample letter, you'll see that we've got some links in one of the later slides to a sample letter that we suggest sending to get that. So once you send it, the legislation kicks in. So under the Official Information Act and under the Privacy Act, provided you quote those 2 bits of legislation in your letter requesting the information, the public agency, in this case the Ministry of Education, then has an obligation to comply within a certain time period that's set out in the law. So that's 20 working days. They may write to you and request an extension. If the file is really big and it's going to take them a long time to copy it or retrieve all the relevant documentation, they might send you a request for an extension. And I've had that happen quite a few times with really big files, so it's not unusual. However, they generally should be aiming to comply with that time limit that's set out in the law. It's important to keep your letters and your submissions really factual. So I can completely understand that it's a very intense and emotional topic to write about, particularly if you are a parent writing these particular submissions, because you live it every day and you know how it feels. And what I would suggest is putting that in a separate document. So having your submissions, your legal submissions, being really clear, factual, and referenced, and then having a separate document which details the experience and a day in the life of your particular young person, because that can be extremely persuasive. The important thing to remember is that Section 10 is a legal process, so you're going to have a really good chance of success if you put forward clear and succinct legal arguments which address the particular points and why, in this particular case, the decision should be overturned as a matter of law. So we suggest that it's important to systematically go through all the applications and reports, so your entire stack plus the entire file that you get from your Official Information Act or Privacy Act request, and pick out all the evidence that matches each of the criteria bullet points. So this sounds quite waffly, but once you have a look at the example we've provided, it'll make a lot more sense. If you look at the next slide where I've got links to some of the examples, it's about systematically picking through all your evidence and making sure that for every point that you make that the particular student meets the criteria, you have specific examples and then you have expert evidence to back it up. So always try to reference back to your professional medical diagnoses or assessments. Be specific. So with legal submissions, you want to reference the page, reference the date of the report, reference the name of the expert, so that it's as if you're preparing the arbitrator to write their judgment for them. You're saying, so the arbitrator can pick out a sentence from your submissions and say, well, at page 6 of Dr. So-and-so's report, it says that, and I find that this supports the finding that student X meets criteria, whatever the criteria is. So what I've done is I've prepared some templates and they're available at these links which are going to come up on the next slide, which show an example set of legal submissions, example oral submissions you want to make when you're actually addressing the arbitrator in person as well, because obviously you need to submit the written submissions well before you actually get to speak to the arbitrator in person and put forward your case orally. So here are some of the templates. Hopefully they're really helpful, and hopefully this is the most helpful part of it because it really gives you a better idea of where to go and how to get started on this sort of stuff. So there are some links for oral submissions on the day, some example written submissions, an example letter making a request for information under the Official Information Act and Privacy Act. So just a bit of overview again of the Ministry submissions. The Ministry submissions will outline the OARS scheme and how it works as a first point of call. Secondly, they'll outline how they assess eligibility. Then 3, that will include the spreadsheet with the record of the verifier's decisions. So once you get the Ministry submissions, I find it's really helpful just to systematically read them and pick out your specific points of response. So what you want to do is find the letter that declined the OARS application, because generally the reasons for decline are summarised there, and then you can pick those out and really pick out where in the application they referred to particular information to support their decision. So very common examples that I see are points that you can raise in terms of the lack of due consideration for particular material that was submitted. Sometimes particular examples which are cited to support their decision, for instance, this child was able to accomplish X, Y, Z extremely well on their own. You can actually pick that apart and explain, well, actually the child was heavily assisted that day, the teacher aide was present, this was a rote learn matter, and the verifiers that came to observe the child only observed the child for 30 minutes and did not see the child for the rest of the day. So that's where it's really important to have that detail. So whether you're supporting a family or whether you yourself are writing the submissions, those sorts of things can be quite helpful. Really helpful if you can get people to come to the arbitration with you. It also makes it a lot more of an approachable process. It's a lot more informal than a court process. So I just want to reiterate that. It's not a scary court process where you have to turn up in a suit. It's quite informal and people just sit around a table, so it's a lot less intimidating than hopefully you think it is. And it's so helpful if you've got people that have got in-depth day-to-day knowledge of your student who can attend and speak to this, to the arbitrator, and the arbitrator can ask them questions. So any questions that they might have about it, they can ask. So I sometimes really suggest people like the SENCO, the teacher aide, a paediatrician, a teacher, a counsellor, a support worker, people that can provide in-depth knowledge and examples of day-to-day life for the student and what type of support they need and what's going to happen if they don't get the support. Really great if you've got those test results and reports, so for instance the JAM assessments from school or the reading assessments, if your teacher, SENCO, teacher aide can speak to those test results and reports and actually explain them to the arbitrator, so helpful. So saying why was it that this particular student achieved this on that day, and this teacher aide might be able to say, well actually that was something we'd done 20 times, they had rote learnt it and I was heavily assisting them, for instance. So here's some suggestions about how you want to guide the witnesses talking to the group at arbitration. So you want to ask the witnesses to speak to the main indicators of eligibility under criteria. For example, what's the diagnosis, what's the history of expert support and intervention that the student has had. One example I've picked out here is criterion 8, and under criterion 8 you want to ask them to talk about firstly the diagnosis of autism, the severe language disorder that the student has, distance from social situations with specific examples, difficulty to engage in learning and social activities. Specific examples are really helpful. How the student is severely distressed by change. So again, specific examples extremely helpful. Being able to put in an expert in clear way, based on their experience and expertise, why the student needs regular specialist one-to-one intervention. I've also listed under criterion 5 some of the things that the witness would like to, would be good for the witness to talk about. So evidence of severe delay in cognitive development, so specific examples they have, specific test results, their expertise and knowledge, really helpful for instance if an educational psychologist is there and talked about that. Major difficulties with learning across all curriculum areas, so generally this is indicated not only by test results but also some of those other scales that I talked about, so the Wechsler scales and things like that, the ABAS scales. The need for significant adaptation of all curriculum content with special teaching strategies and methods. So this is probably something your TA or your teacher or your SENCO really has a lot of expertise and is going to be invaluable with. If you're wondering, is it worth my while asking all these people to come? Absolutely. My experience has been it makes a massive difference to the arbitrator being able to form a view on the case and understand the day-to-day struggles of a student when you've got a number of professionals who are experienced and can give these specific examples and explain why and how there are limitations within what the school can offer within its bulk funding in these cases. So here's some example questions to ask. I'm not saying that this is the perfect list or anything. Definitely feel free to add or remove, just a guideline. So, you know, what's the diagnosis? How long have you known the student? What is your experience with the student? What do you think the student needs? What do you think, what does he or she currently get? What do you think they need to succeed? What will happen if they don't get the support? So really nice to show that there will be academic lag, social lag, and the potential ramifications of that. How they see the student fits the criteria, which we've discussed earlier in slides, and talking to school results, tests and reports. So for instance, one of the big measures under Criterion 5 is ensuring that a student is working within level 1 of the curriculum. So if you've got test results that indicate that, or they're able to indicate, well, the student is so heavily scaffolded, that's why it indicates that they're working around that level, that gives a lot of evidence and clout to the case that you're presenting. So any other matters? So what I always suggest in these situations is you ask as many questions as you want, clarify as many points as you want, because it's your process. The Section 10 wording is really clear. It's the parent's appeal, it's the parent's process, it's the student's right to education. So, you know, when you're going through this process, don't ever feel like you can't speak up, you can't ask questions, you can't clarify, and always feel that you just, if you want to put more information forward or say more, go ahead and do it, because this is your only chance to do it before the arbitrator goes away and makes a decision. And if the appeal is unsuccessful, you've got a 12-month stand down. So make sure that you've asked all the questions and done everything that you want to do, or put forward everything you want to do. If you feel that the arbitrator has acted unprofessionally or inappropriately, there are codes of conduct which relate to arbitrators, provided that they are one of the affiliated arbitrators with the particular organisation, and also there are general codes of conduct, and also the Ministry of Education has their own code of conduct and oversight over these arbitrators as well. So it could be that if you genuinely felt there were some issues with that, you could make a complaint to the regulatory body and the Ministry of Education about the particular arbitrator, and perhaps, you know, seek a rehearing with a different arbitrator if you felt there was bias or any issue of that. Beyond that, there's also court action which is available through judicial review. Now, judicial review is not something that's undertaken lightly. It essentially involves showing that there was an error of process and some fundamental flaw which occurred, and going through the High Court through judicial review is in the proximity of $30,000 instructing a private lawyer, and it takes a substantial amount of time and evidence. So it's not a route that would be recommended generally. Following the complaint mechanisms through the Ministry of Education or otherwise are probably the preferable options. One of the great things that the arbitration does allow you to do is it's usually a senior level Ministry of Education representative, which means that they have the authority and ability to canvass lots of other support measures that might be available if OARS is not available. So that's a really helpful thing, because it means you can really pick their ear and really find out if there's anything else that might be available, and they can put those things in place immediately after the hearing. You don't have to wait until the outcome of the arbitration if it's something that could be provided in addition to what you're asking for. I really strongly suggest that this should be taken advantage of, because, as I said, there's a 12-month stand down if the appeal is unsuccessful, And while you've got them captive, so to say, it's always good to have that constructive dialogue. After the arbitration, if you're successful, fantastic. Then you go through, as I said, the moderation process to determine the levels of support that the child is going to receive. So it doesn't mean that every child receives the same amount of, for instance, teacher aid time or otherwise under the OARS application. If it's unsuccessful, as I said, you've got a stand-down period of 12 months, so you can't apply for OARS again within that 12-month period. You can reapply after that period, and what I suggest to people is you should always keep a record over that time of academic testing, declines, any reports over time that are showing there's been a lack in academic progress due to the lack of support, and how this has really detrimentally impacted on the student. There is the potential also then to lodge a complaint with the Human Rights Commission. So potentially, if you are interested in this, there's a lot more information in one of our earlier webinars, the earlier webinar which I referred to earlier about special needs students being supported in school. In that webinar I really outline the right to special education and how it comes about. So for instance, the domestic law under section 3(8) of the Education Act, and also the international conventions. In particular, I'm thinking of the United Nations Convention on the Rights of Persons with Disabilities, Article 24, and the United Nations Convention on the Rights of the Child. That altogether provides you with the legal basis for a potential claim of discrimination, also arising under the Domestic Human Rights Act and Bill of Rights Act in New Zealand. If you can make up the argument that the Ministry has failed to provide the adequate support needed for this child to obtain their right to special education, therefore they've been discriminated against, therefore you're lodging a complaint for mediation in the Human Rights Commission. It's a really simple process to go through the Human Rights Commission complaint process. It's just, you can just lodge it online, or you can call up the Human Rights Commission and seek a mediation, and there are such helpful staff there that can talk you through the process. So that's the Human Rights Commission, always an option if you're in that 12-month stand-down period and you really feel strongly about taking some further action. Human Rights Commission could be a good option, because mediation is an informal, private process. It's all confidential, and yeah, generally you would get also a senior ministry representative come and meet with you and mediate with you. After the arbitration, there's nothing to stop you, again, contacting the Ministry of Education and liaising with them about other support that's available. So I know that the in-class support initiative has been rolled out recently to help catch some of those students that might not meet OARS funding. There's high health needs, the severe behaviour intensive service, and the IWS service, which I mentioned briefly before. So it's worth investigating all these things to see if any of these might be of assistance in the meantime, because those things are definitely available within the 12-month stand-down period. It's just that you can't apply for OARS again within the 12-month stand-down period. And I've just seen a question pop up from Wendy. You mentioned earlier a Ministry of Education representative attends the arbitration meeting. Is that representative the MOE, team leader, or the regional manager? Very often it's both. So sometimes you'll get up to 3 people attend, sometimes 2. So at the arbitration you'll generally have the Manager of Quality and Assurance attend, and potentially also the regional manager who deals with that student in that particular region and is aware of the applications that have been made and what supports and provisions are available. The great thing is, if you've got the regional manager there, they've got the authority to talk about what other supports might be available if OARS is not successful. When you're going through the HRC mediation process, you generally have up to 3 people. So you would have potentially a senior regional manager, and depending on the nature of the claim, also a local team leader. It will just depend. So I've experienced various levels, so depending on the type of case and what the claim is, it will affect who does come to your mediation. But yeah, there have been times when national managers have also come to mediations with me at the Human Rights Commission. And you're perfectly within your rights to ask who's going to attend. because I'd like to know, and hopefully the HRC or the arbitrator can give you that information. If you do want to bring like lots of different people to arbitration, it's important to bear in mind that it's a legal process. So I would always check with the arbitrator. I would say to the arbitrator, is it okay if I bring Auntie June, for instance, as my support person, plus I'd like to bring XYZ, and just keep the arbitrator informed and say, look, my list of people I'd like to come to present information is the SENCO, the teacher aide, the paediatrician, so I would like these people to come, and generally the arbitrators not going to have an issue with it, and it's just keeping everyone informed and in the loop so that they can allocate adequate time for the arbitration, and if there are any genuine concerns about any person that's attending, it can be raised beforehand so it doesn't become an issue on the day. You can ask who the ministry intends to bring, and if you have concerns, so sometimes I hear from parents that they have particular concerns, for instance, with a particular person that they've been dealing with in the ministry, and if that person is coming, if you genuinely feel that you would be uncomfortable with that person attending, or you couldn't manage an arbitration with them, tell the arbitrator, and the arbitrator has got processes to work through that with you. The important thing is that arbitration is a bit more of an informal process than a court process, so you're not going to be stuck in the situation where you feel like you're going to have to put up your hand and say, Your Honour, could I please say something? It's a lot more informal. People are sitting around a table, and generally you'll break for lunch in the middle of the day. And you can take breaks if and when you need to, because I can understand it can be an incredibly emotional and exhaustive process. So here's some other tips. So this is kind of what I'm talking about when you're sort of out of the OARS realm and you're trying to advocate in general for a right to special education. And go back and have a look at our other webinar if you want in-depth information on this. But reminding us, if it's a school that you're having difficulty with in terms of accessing general bulk funding support, or if it's other initiatives from the Ministry of Education, such as the Behaviour Initiative or Communication Service or something, and you think that the student is entitled and should be getting this support, reminding them of their obligations. So Section 3 of the Education Act sets out a basic right to education for all children between the ages of 5 and 19. So the child should be able to access a right to education which is state-sponsored at their local public school. Section 8 of the Education Act is the one which deals with the right to special education. So all students, whether they have special educational needs or not, are entitled to access an education which is at a level comparable to their peers that don't have special educational needs, and that is state-sponsored, and it should be provided in a way which meets their needs. Refer to the New Zealand Government Disability Strategy. Lots of vital information in there about how we need to comply with our domestic and international obligations, and how the government has aspirations to ensure an inclusive education system and inclusive society in general. Refer to the United Nations Convention on the Rights of the Child. So that's a major piece of international law New Zealand government has ratified, and it sets out the right to education for all children. The other convention I've referred to there is the United Nations Convention on the Rights of Persons with Disabilities, another crucial international convention which was ratified by the New Zealand government in 2008. Article 24 is the key article. It talks about the fact that there's an obligation to ensure that students have their needs met, and talks about a concept of reasonable accommodation. So reasonably accommodating those students in the mainstream so that they can achieve a standard of education that is of equal and comparable level to their peers. So advocacy that I'd suggest in these circumstances is to set this all out in writing to the school or the Ministry of Education, and if you're not really getting any traction with that, the next step would be to lodge a complaint with the Human Rights Commission and seek mediation to try and talk out those issues. My experience has been that I've had a lot of really successful outcomes following a complaint to the Human Rights Commission, because you've got an independent mediator who's there to facilitate a solution between the parties, and it's often very helpful because a senior Ministry of Education representative is attending who has the authority and ability to say, well, actually this funding is available, or this support might be available, and put it into action. And a really good part of the human rights mediation process is that you get a signed settlement agreement which is enforceable. So you can take further steps to enforce it beyond that. So hopefully that's given a bit of an overview about sort of how to approach these things. And I've just seen another question pop up from Anna. Do the OARS verifiers ever visit schools to observe the child in question? And the answer is yes. So very often if you've got a case which is quite close, the verifiers can't agree, or where they think it is appropriate, verifiers will come out to the school and observe the child. So it's really helpful to give the verifiers context when they do come to observe the child, because very often what happens is the verifiers might only come for a short period, and it might be a time when the teacher aide is with the student and they're heavily supported and they're doing something that they've learnt, or they're heavily assisted by a device, and so the verifier might form an opinion of the student's achievement levels which are not actually factually accurate. So very helpful sometimes to provide the context for that. And yeah, if there's ever a situation where as a parent you don't feel comfortable, speak to the school about it and arrange a situation where you do feel comfortable. So if you feel that the verifier is coming at a particular time of day, or who the verifier is coming with, such as the person you've been dealing with at Ministry of Education office and you're not comfortable with it, talk to the school and talk to the Ministry and say about how you'd feel more comfortable, or that you'd like to spend some time talking to the verifiers explaining your point of view or your concerns, because they should give you a reasonable opportunity to put forward your views. Essentially, you remember I talked in the earlier slides a little bit about Section 9 of the Education Act and IEPs. Well, it's pretty clear, and a lot of the commentary is pretty clear, and the international conventions are pretty clear, that it should be a collaborative process. The school and the ministry should all be working together to sort of formulate as much information as possible to best meet the needs of the student, and that involves working collaboratively with you and listening to what you have to say. And certainly you can raise that as an issue if you feel that that's not occurring. So secondary question from Anna, can that visit be requested as part of the review reconsideration process? As far as I'm aware, there's nothing to preclude you from asking for it. Generally the process, which I understand is part of the internal ministry policies, is that occurs prior to the decision being made on the initial OARS application, for instance, or it will occur during the visit prior to an appeal. But if you consider that it's really relevant and important that this is new information that they could consider as part of the review reconsideration process, I don't think there's anything that would preclude you from asking them to also include a further visit. So hopefully that answers the question for that. If anyone doesn't have any further questions, I'm just going to flick forward to the last slide. Obviously, a lot more information or advice about a specific case can be obtained by calling our 0800 number. It's staffed by volunteers who answer the phone, take down those details and pass it on to a lawyer who will then get back in contact about any information or advice about the case that they might be able to offer. There's lots of information available on our website. In particular, you notice that I referred quite a lot to previous webinars we've done in education law. Worth having a look, particularly the webinar about special educational needs. We're on Facebook. We recently published a report about provision of special educational support in schools, and that's available on our website and up on our Facebook page. We also actually did a report on Kiwi suspensions to do, and a lot of it crossed over with the informal removal of students with special educational needs from school. So for those that are interested, feel free to have a read. We have an app you can download for your smartphone. It's got lots of basic information about rights of young people, and Google, you can get that from iTunes and Google Play. I'd really appreciate if there is any computer that's been used by more than one person, really appreciate if you can just type that into the chat box and let us know. We require that information for reporting purposes. Also, please, I'd really love it if you could do our webinar survey. We just need that for reporting purposes as well. It's just a short survey and it enables us to ensure that we can provide you with better webinars in the future, and we are doing a good job. So any feedback you can provide would be really helpful. And Valda's just put in the box fantastically. If you are a professional watching this and you require a certificate showing that you've participated in this webinar, feel free to contact us and we can arrange that as well. So I'm just going to leave the chat box open for another minute or so just to pick up any final questions from any people. Hopefully that's been helpful for you. I look forward to your feedback on how the webinar was helpful or not helpful. And obviously if you've got any specific questions or a specific case, feel free to get in contact with us. Thank you for attending the webinar, and we hope to see you again in future.
Thank you very much.
Yes, thank you. That was really good. Appreciate that.
Could I just make one comment?
Sure.
Material I got from the Ministry suggested that up to 35 to 40% of Augurs funding applications are declined every year, and that's happened for the last 7 years.
Yes, so we did actually request some official information around that, and yeah, we understand the figures are around that. A lot of the feedback that I've received about that is also to do with the lack of expert reports with some of those applications as well. Not saying it's a fair system, but certainly it's a system that's geared towards medical and expert evidence from our experience. It's certainly not fair, because if you're a family that you know, is forced to rely on the report that's been generated by the Ministry of Education expert and you don't have the funds to instruct a private expert, that can put you in a very difficult position. So it's not the most fair system in that sense, but certainly the feedback that I've received is that where there is expert evidence, it is a system that's geared towards expert evidence which supports those specific examples which are given, particularly those objective tests that have been administered, like the Wechsler and Avast scales, for instance.
So are we told when there's a declined application, are we told the reasons?
Yes, you will receive a letter. Usually it's relatively brief, it's a paragraph, and it will reference, for instance, key aspects of the application that they feel were not strong enough, and generally it will refer to specific examples. So a lot of the letters I see refer to observations that the verifiers have made about a student being particularly successful at doing one particular task when observed. And what I say is, you know, when you're going through the review or appeal process, you pick that apart and you explain why that's not an accurate assessment. Great. I don't think there are any more questions as far as I can see. So thanks everyone very much. Obviously if anything springs to mind that you desperately want to ask me, feel free to come contact Youth Law or contact the 0800 number, and very happy to chat. Otherwise, thank you very much for attending, and we look forward to your feedback in the SurveyMonkey survey.